Mississippi House of Representatives is now in session. Please let the House come to order. Please stand as we're led in prayer today by the gentleman from Simpson. Remain standing there for the pledge.
Good morning. Let's go to God in prayer. Our most gracious Heavenly Father, we're so grateful for this day that you've given us. Father, we're so thankful for you loving us enough that you sent your Son, Jesus Christ, down here on this earth to die on the cross, to forgive us of our sins and give us that eternal home with you when we leave this earthly home. Father, thank you so much for the members here today who serve their state, their constituents. Father, I ask you bless each one of them. Father, I ask that you be with us today as we go about the business of this state. Guide and direct us as we make our votes, that it will be pleasing and profitable and bountiful and good for our state. Father, we love this state. We love this country. We love its people. Father, I ask that you guide us, give us where we fail you, and we're so thankful for all the blessings you've given us. In Jesus' name, amen. Attention, salute, pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Open the machine, Madam Clerk. Close the machine, Madam Clerk.
There's a quorum present, Mr. Speaker.
Thank you, Mr. Clerk. We'll have the reading of the journal. Gentleman at Wamba moves. We dispense with the reading of the journal. All in favor say aye. Opposed, nay. The ayes have it. Report of select committees.
We have none, Mr. Speaker.
Report of standing committee.
We have reports on the calendar, Mr. Speaker.
Introductions of bills and constitutional amendments. Gentleman from Marion, Mr. Morgan.
Thank you, Mr. Speaker. We ask unanimous consent to dispense with the reading of the introduction.
Is there objection? Hearing none, we will do that. Resolutions, petitions, memorials, and other papers.
We have none, Mr. Speaker.
Thank you, Mr. Clerk. This time we'll have introductions of guests and visitors. Gentleman from Hancock, Mr. Anderson. Gentleman from Hancock, Mr. Anderson. You got an introduction you'd like to make?
Are we on? I'd like to recognize my lovely better half, Maureen Anderson, today. She's sitting here with me today, and she'll keep me in line today. Thank you, Mr. Speaker.
Great, great. Any other introductions? I don't see any. I do have one announcement to make, ladies and gentlemen. It is my understanding that last night at the Junior Sale of Champions at the Dixie National Rodeo, there came down to a showdown between the House and the Senate on who could win with the best animal. And I'm proud to announce that our own Sam Creekmore won and carried the day. He did. So we are proud that he stood up for us. Congratulations, gentlemen. I heard you got a big belt buckle. Is that right? You wearing it today? He said he couldn't figure out how to put it on. So some of you belt buckle wearers need to help the man. All right. Don't see any further introductions. We'll go to the calendar. Motion to reconsider. Any chairman have an item here? Gentleman from, where are you from? Grenada, Mr. Horan.
Currently, Your Honor. Item number 4, 747, I moved it to the reconsider for purpose of an amendment.
Motion is to reconsider. All in favor say aye. Opposed, nay. Ayes have it. Gentleman's recognized.
Thank you, Mr. Speaker. I recognize the gentleman from Rankin to offer up an amendment.
Gentleman from Rankin is recognized to present an amendment.
Thank you, Mr. Speaker. Thank you, Mr. Chairman. I have a amendment that this is this bill is about rehabilitation when people are in local jails. And what we're doing is adding Mississippi Prison Industries as a way. A lot of these jails would not have the capability of doing this rehabilitation, and so Mississippi Prison Industries has agreed that they could help with some of these jails, and actually help in some instances with Mississippi Department of Corrections. So that's what the amendment does. Any questions?
Questions on the amendment? I don't see any. If you favor the amendment, indicate by saying aye. Opposed, nay. Ayes have it. Amendment carries. Anything further on the bill?
Move final passage.
Questions on the bill? I don't see any. Open the machine, Madam Clerk. Question occurs on House Bill 747. Favor the bill, vote aye. You're opposed, vote nay. Has everyone voted? Has everyone voted? Closed machine, Madam Clerk. By a vote of 121 yeas, 0 nays, the bill passes and flies away. 747. Get it? All right. Any other chairman have an item on the motion? The gentleman from Alcorn, Mr. Bain.
Thank you, Mr. Speaker. I would, on item number 5, House Bill 122, move the table.
Motion is to table. Those opposed have 5 minutes. Any opposed? I don't see any. If you favor the motion, indicate by saying aye. Opposed, nay. Ayes have it. Gentleman from Rankin, Mr. Powell.
Thank you, Mr. Speaker. Item number 6, House Bill 1063, move to table.
Those opposed have 5 minutes. Any opposed? I don't see any. If you favor the motion, indicate by saying aye. Opposed, nay. The ayes have it. Gentleman from Itawamba, Mr. Boyd.
Item number 1, House Bill 1315, move to table.
Those opposed have 5 minutes. Any opposed? I don't see any. If you favor the motion, indicate by saying aye. Opposed, nay. Okay, the House is not voting. Motion is to table. If you favor the motion, indicate by saying aye. Opposed, nay. That's pretty weak all the way around, ladies and gentlemen. The ayes have it. The ayes have it. All right. Any other item any other chairman have an item? I don't see any. All right. Takes us down to the rules calendar. He passes. Brings us to the Ways and Means calendar. He passes. Laid on the table calendar. He passes. Brings us to the general calendar. Item 1, Judd B.
Thank you, Mr. Speaker. Item number 1, House Bill 80. I'd call it up and make a usual motion.
Gentleman calls the bill up, moves that the rules be suspended. Bill considered engrossed, read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it. Gentleman's recognized.
Thank you, Mr. Speaker. I want to make a motion to lay that one on the counter.
I don't know that we have such a motion. You mean on the table or all the way on the counter?
On the table. Lay it on the table.
Motion is to lay on the table. All in favor say aye. Opposed, nay. The ayes have it. All right, brings us to item 2, corrections.
Thank you, Mr. Speaker. Item 2 is House Bill 525, is the Corrections Omnibus Bill. This basically has code sections similar to that in 1377 from last year with no changes. It adds the asset forfeiture code sections as well as the pretrial intervention code sections. There are no changes, and it has a reverse repealer. That's the explanation of the bill, Mr. Speaker.
All right, gentlemen, we need to call that bill up. Gentlemen,
I'm sorry.
calls the bill up, moves that the rules be suspended. Bill considered in gross read the third time, placed on final passage. All in favor say aye. Opposed, nay. Ayes have it. You got a committee
I
substitute,
do.
gentlemen.
I move to adopt the committee sub, Mr.
Gentlemen,
Speaker.
moves committee substitute be adopted for consideration in lieu of the original bill. All in favor say aye. Opposed, nay. The ayes have it. You recognize, gentlemen.
Thank you, Mr. Speaker. This omnibus bill is just the code sections that were in 1377 last year with no changes with the reverse repealer. In addition to the same code sections, we have the asset forfeiture code sections in there as well as the pretrial diversion code sections and a reverse repealer. That's the explanation of the bill, Mr. Speaker.
Questions? Lady from Lincoln, Ms. Curry.
Thank you, Mr. Speaker. Will the gentleman yield?
Certainly.
Why would
Excuse me,
you?
lady. Excuse me, lady. A little loud in here. Please hold it down. People having trouble hearing. You may continue, lady.
Thank you, sir. I'm wondering why you're bringing forward the forfeiture bill. This legislature defeated that pretty unanimously the last time.
I'm not bringing it for any substantive changes other than trying to figure out what we can do with some of the funds from asset forfeiture for reentry, madam.
Thank you.
Gentleman from Madison, Mr. Bumgar.
Thank you, Mr. Speaker. Gentlemen, you yield?
Yes.
Gentlemen, similar question. I just want to make sure administrative civil asset forfeiture or anything related to stuff that we did away with is not going to come back in any form this session.
No, sir, gentlemen. The only reason I have those code sections in there is, like I told the lady from Lincoln, is to figure out maybe some way we can channel some of these funds through asset forfeiture back into reentry and back into reentry courts, things of that nature, as opposed to just, there's a certain amount that we need, I think, capture. I believe that if you're going to stop some of the problems within the drug community, those individuals who've had their assets forfeited, some of that needs to go back into the system. And I think that's what we need to be doing.
Sounds like great ideas, gentlemen. Thank you.
Thank you.
All right, I don't see any further questions. Open the machine, Madam Clerk. Question occurs on House Bill 525. If you favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Close the machine, Madam Clerk. By a vote of 111 yeas, 0 nays, the bill passes. Next item.
Thank you, Mr. Speaker. Item number 3929, call it up with the usual motions. And
Jim calls the bill up, moves the rules be suspended. Bill considered in gross read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it.
I move the committee so be adopted, Mr. Speaker.
Gentleman moves committee substitute be adopted for consideration in lieu of the original bill. All in favor say aye. Opposed, nay. The ayes have it. Gentleman's recognized.
I move to lay it on table subject to call, Mr. Speaker.
Motion's to lay on table subject to call. All in favor say aye. Opposed, nay. The ayes have it. Next
Thank you, Mr.
item, public utilities.
Thank you, Mr. Speaker. I'd like to go to item number 4, House Bill 942. Call it up, make the usual motion to move the committee sub be adopted.
Gentleman calls the bill up, moves that the rules be suspended. Bill considered in gross read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it. Gentleman moves committee substitute be adopted for consideration in lieu of the original bill. All in favor say aye. Opposed, nay. The ayes have it. Gentleman's recognized.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, this is a bill that has brought before you. A lot of conversation about this bill and what it does. I'm just makes personal opening remarks in this preamble in that this is a bill that I've worked on with all of the parties involved for, gosh, I don't know, the last several months, trying to find common ground for us to be able to get broadband accessibility out to the most inner reaches of the state. And this is one mechanism that we can do it. I will tell you that I think what I'm proposing is good broadband policy. It would allow the investor-owned utilities to lease their unused fiber capacity that they have in their electrical systems to third-party providers for broadband access. So I think it's good policy what they're doing. It is, this unused fiber is, they use it in their electrical systems for communication between substation to substation, substation to headquarters and things like that. But in this capacity, they have unused fiber. They have unused fiber capacity, which we all know right now is the standard for speed and reliability in broadband transmission. Now, so these IOUs, these investor-owned utilities, they do not want to get into the broadband business themselves. That's not what their end goal is. Their end goal is to be able to lease this unused fiber capacity to a third-party provider, whether it be a telecom, whether it be a cable entity, whatever. They want to have the ability to lease this unused capacity in their fiber system. And with this bill, that's what they would do. I just want to start real quick. I'm going to go through the bill quick, and then I'll make some closing remarks, and then I'll take questions. Section 1 is just a legislative intent of what this bill does. Section 1 has definitions, various definitions that is used throughout the bill. Line 129, which is where some new language in, this deals with the Public Service Commission. This allows them at some point, and this is language they have asked for, to enter into agreements with state agencies or institutions of higher learning to gather data, collect data, to where we can, that data can allow us to have better information on broadband maps and broadband coverage as we go forward. It's just, I think it's very good language that the PSC has asked for, and I think right now, and I will tell you this, that the data that we have to rely on is at the best very inaccurate, okay? The FCC maps are very inaccurate. This right here will allow, in section, on line 129, would allow the PSC to do a lot of what Georgia has done, the state of Georgia. The state of Georgia has done this privately on their own, and they have a lot better assessment of what their broadband coverage is in the state of Mississippi. Line 229 is just some revised definitions that we go through. Lines 330 to 337 is actually the permissive authority for the broad IOUs to get into this. You know, lines 358, I want everybody to understand what this does. There's language in there about just and reasonable rates and it being non-discriminatory. So let me tell you what this does. If and when this legislation is passed and this language stays in there, and this language we move forward with this language, this just says that these IOUs can't be discriminatory against any company, that they would have to provide just and reasonable rates. And since they are rate-regulated utilities, these rates that would be, quote, just and reasonable could be determined by the PSC. So I've had some questions from some of you in regard to this. Well, how are they going to know, you know, who they can lease to this unused fiber capacity? I will tell you this, that I'm a capitalist and I believe in the free enterprise system. And I believe that these companies, if they have unused fiber capacity, that they get out there, and if they want to put it out for bid, that they take the best bidder for that. Okay, here again, keep in mind that they're not getting into the business themselves; they're leasing it. So, I think it's good for them to be able to have that ability to pick that provider who would be the best provider for that broadband service or that broadband capacity that they are offering. Lines 366 is very important. This says if these IOUs get into this or lease this capacity, that no purchase of broadband from their lessee or lessor is required as a condition of electrical service. In other words, you ain't got to get broadband to keep your electrical service. There's protections in there for that. There's no discount on your electric rates if you take broadband service from their lessor, okay? So protections there. They can't, if you don't take their broadband service from their lessor, they can't come cut off your power if you don't pay your broadband bill. They can't come off your cut off your power for things like that. So there are protections many protections in there in this bill, starting on line 366 for the ratepayers. Lines, bear with me, lines 380 just grants permission of large economic development projects to use these IOUs infrastructure if they meet a certain megawatt usage per month. Very simple language. Line 388 is language that specifically the IOU bills, and let me y'all listen to me, specifically on line 388. This is the easement language. This is a language they came to me and said, for us to get into this business, we've got to have this language. And what it provides for basically is that if an electric company already has fiber running underground or on poles or whatever across agreed to easements with a landowner, that landowner is not entitled to any other payment or anything just because it's used for a different purpose. That commodity is already there. It's already there, okay? So that's on that line. Lines 463 is new language. This deals with the railroads. Everybody was in agreement with that on railroad easement language. And line 477, this is very important too, as if these companies are able to lease this capacity of this broadband to a third party, the revenue that they would provide as owners of the commodity would be put back into the rate base of the ratepayers who paid for this commodity initially, okay, and would be given as an annual credit to the ratepayer. So that is a good thing too. Lines 493, just simply the electric rural co-ops takes them, none of this just says, none of this language pertains to them. Ladies and gentlemen, that's a brief overview of the bill. I know most of you have had conversations with different special interests in the halls and out, and there is, I think this is good policy. Section 4 of the bill does allow, there is one restriction in there that says that in areas where there is at least one provider, where it provides 25.3, they would be restricted from going into those areas, 25.3 download speed. I want to share with you just real quick a story I had with a gentleman from Leak yesterday. He came up to me after we adjourned yesterday and he said, Mr. Chairman, he said, I want to ask you a question. He said that I know that in my area, I have people who do not have any broadband service whatsoever. I've got this satellite and it's not any good. Just says, it's not good, but I don't have any other service. But I know that some of these electrical companies that serve me have electrical lines and fiber capacity running right past my house. Would this bill allow them to lease that fiber and serve my people in these unserved areas? I said, absolutely. This is the full intent of this bill, is for them to use this unused fiber capacity, on which I think is good broadband policy in the state of Mississippi, for them to be able to do that and let them get this out to the people who need it most. This will become effective July 1st, 2021 from and after passage, and I'll entertain any questions, Mr. Speaker.
Gentleman from Lauderdale, Mr. Young. To your left.
Thank you, Mr. Speaker. With the gentleman yield?
Yes.
Gentleman, you said something that caught my attention on the end regarding the service provision that's already being provided and there being a no compete that's entailed. And I think you said if service is being provided at 25 megs or above,
right,
then
yes,
there's a non-compete.
Yes. So to instill some fairness into what I think is the legislation, it does have a restriction, and if there's an area that is already served, and this is in section 4, already served by at least one provider who is providing right now the FCC minimum of 25 megs down, 3 megs up, they would be restricted from going into those areas. Further in section 4, it says that if and when new data becomes available, that we can change that definition of an unserved or underserved area. But for now, I have put that in there as a matter of fairness because we are dealing with rate-regulated utilities whose commodity has been put into place by the ratepayer, so it's just a degree of fairness in my mind, gentlemen.
Gentlemen, may I ask one additional question? with regard to everyone using, video terminology and downloading a lot of video content and us doing Zoom and everything else, do you think that 25 meg threshold is going to be adequate?
Gentlemen, I will tell you what I know about it. For most households, 25 megs down is adequate. There can be some concessions given on the upload speed because there are more things being done by Zoom and all of that. But I will say, this is a moving target. This is a moving target in all states because we are having this conversation that's being had about FCC data maps being inaccurate, speeds being inaccurate, and things like this. This is what I think we have the best to go by here. It does offer some protection for those that have not had the ability to have commodity like the fiber put in by the ratepayers. As we move forward through the process, I think, we hope as we move into the future. If you recall back when we did the Broadband Cares Act back in June or whenever it was, back when we finished up the session, that with the co-ops, we required 100 speed, and they have gone out and done this. But this being the threshold minimum, that's what most states are working off of now, but we are certainly looking to the future, and hopefully speeds will increase in these rural areas.
Gentlemen, are you familiar with the term throttling?
If I am, I don't recall. I'm sorry.
What it does is it provides a provider an opportunity to say that we're giving a speed of X amount, and then say at 11 o'clock during the day.
Oh, you're talking about data caps. Data caps, where they're putting data caps on it?
Well, no, I'm talking about during a peak period for transmission, the provider will slow the rate down
I'm familiar with that, or reading that in fine print in some policies on email solicitations I get on getting new devices and everything else, that they can slow speeds down, but this bill does not address that, gentlemen.
Well, my question there is if we have a maximum of 25, my maximum is 150, and I think it's too slow. But at 25, and if they're allowed throttling, then my question is, will content provision be available?
Gentlemen, I think so. I live and I live in a subdivision in the city of Philadelphia for years and years and years, up until July of this year, when I made a switch. I had at the most 6 megs down and maybe 2 megs up. Now, I will tell you, I don't do a lot of streaming on movies and things like that, but for what my wife and I did for us, just basic work, Zoom meetings and things like that, the 6.3 was sufficient. Is it slow? Yeah, it's slow, but we made it. 25.3 is just the definitive term, or what as it's called in terms in the industry, minimum threshold. The 25.3 is a minimum threshold, and I'm sure as more data is collected, more information is gathered, and that's why I want to engage the PSC on this, allow them to work with mapping companies, our institutions of higher learning, and let's get a better definition of what the minimum threshold for the state of Mississippi should be, and then at that time, we can put that into a policy position.
Thank you, gentlemen. I think you got a good work in progress.
Thank you, gentlemen.
Gentleman from Tallahatchie, Mr. Rosebud.
Would the gentleman yield?
Yes.
So on here, just trying to get some clarity to section 4 for myself.
Okay.
So it says unserved or underserved based upon FCC's definition, right?
Let me get to section 4 and be sure I'm got the right language. I know I do. I've worked on it. Yes, yes, gentlemen, yeah. For the purposes of this act, that's the key to this, okay? For the purposes of this act, in other words, we're defining, there's probably untold definitions out there in the industry of what unserved or underserved is. But for the purposes of what we're trying to do in House Bill 942, We are defining unserved or underserved areas as what it says right there. Those areas lacking broadband service, capable of delivering 25.3, which is a minimum threshold.
So in this bill, I want to make sure that we're actually going to be giving the individuals the service, because we know, with the FCC standards right now, where it says unserved or underserved, if I'm the only person on my block that has internet service, then according to FCC, it shows that everybody within my block and everybody behind me has service. And so that would be with them a served area, because they already have service there.
Gentlemen, if you, throughout the bill, anywhere where unserved or underserved is mentioned, I don't reference anything to the FCC maps, because we all know and all agree that those are inaccurate, because you are exactly right. In a census block, you can have, and if you've got a census block, and I don't know how many people's in a census block, but if you have 500 people and one person has internet service in that census block, the FCC technically can claim that census block as served, and it's not really served.
Right.
Okay? So there's I want the body to understand that I'm not referring to FCC data here for the purposes of this act. I'm defining underserved and underserved. That's what we're doing it, trying to keep some safeguards in, but still then allow, gentlemen, these investor-owned utilities to get out there and let's get that unused fiber capacity to the constituents, sir.
Thank you.
Thank you, sir.
Gentleman from Washington, Mr. Hines.
Thank you, Mr. Speaker. Gentleman, yield.
Yes.
Gentlemen, I'm for providing service for underserved areas. But what assurance do we have with this piece of legislation that our folk won't get gaffled like the co-ops have gaffled people in regards to getting services? Because we have several people who fall upon, you got some co-ops who don't even want to do it. So what reassurance do we have that this will get done?
Well, gentlemen, there is, so I'm going to answer your question as directly as I can, and it's to my best of my knowledge. There is, and as I explained to the gentleman from Leak yesterday, there is no mandate in here that these IOUs have got to do anything. All this does is give them the authority to to lease this unused fiber capacity. We are hoping that they have come to us. We have given them the easement language, excuse me, that they have asked for, and we hope, it is our intent, it's the legislative intent as it is stated in Section 1, for them to be able, they've come to us, they've asked for the authority to do this. We want to give them that authority to do it. But gentlemen, there is no mandate in here that they have to do that, okay? So it's an opportunity. It's an opportunity. It's an unused commodity out there. And if they are serious about wanting to get into the business, I know that they have lessors who are chomping at the bit right now to do it.
So gentlemen, hopefully you can answer this question to me. When I first got here, there was this big conversation about wireless communication, and we gave the wireless group over there,
right, Wireless Commission,
and they were supposed to be establishing foundational principles for the underserved, along with setting up a statewide communication system for police officers, fire departments, and all that stuff.
Which is 98% built out now.
Okay, now that you said that, it's 98% built out. So if they have built out a system, why don't we have internet services in these rural areas?
Well, gentlemen, as you know, I don't know of any government entity that is in the internet business, okay? Private companies are in the internet business. These IOUs are private companies. They want to lease this fiber. Now, I will tell you that through the years, through the Rural Digital Opportunity Fund, RDOF, everybody's familiar, just saw that Mississippi was awarded $495 million over the next 10 years, $49 million a year to providers to provide rural broadband service. FCC will be monitoring that very closely. looking, and so I'm deviating a little bit, but I'm going to come back to your answer, gentlemen. In that, this legislature, not just like we can't force any other private business to make decisions that may, impact their bottom line or anything else. They're private companies, just like a lot of us are all in private business. We want to do what's right. We want to provide what we can, but there's no mandate in here, and there's nothing, gentlemen. I will tell you that House Bill 505, that if we get past this one that is coming up next, I think will, as I explained, it may offer you some more answers to your questions. But in this bill, gentlemen, I will tell you this, that, for years, broadband expansion in the state probably has been slowest at best, okay? We are a very rural state, but that still doesn't create an excuse for those people who need it the most not to have it. This will allow them to do that, and then we want to create every opportunity that we can, gentlemen, to get that out there.
Well, gentlemen, here's my concern. Would you agree that every child in this state deserves a right to have a quality education, and because of what is taking place with COVID-19, we find out that kids won't have and have not had access to internet services? And so don't we owe that to those children of this state so they can have a brighter future?
Gentlemen, I would not disagree with you all on that statement. However, I will go back to what we did pass back in the session that we just completed in the fall or late summer in House Bill 1708, House Bill 1716, to where we provided $150 million worth of devices to the public schools and $50 million to hotspot connectivity. But gentlemen, I will agree with you, and I love you to death. There's still more work to be done. I agree with you.
Gentleman from Marion, Mr. Morgan.
Thank you, Mr. Speaker. Gentleman, you?
Yes.
I've had a little trouble hearing you because I guess a lot of people hadn't got as many phone calls about this broadband as I have. It's kind of got personal to me because I about wore Randy Russell to death over it. After Katrina, there was a lot of money put down to the federal government to put broadband, fiber optics and all, where they got the cables and all buried, got them thousands of, not hundreds of thousands of miles of cable buried in the state of Mississippi. Is that right?
Gentlemen, I would trust your statement on that.
And we possibly run into an avenue where we got all the cable down and everything. We didn't have enough trunks to provide the service to the rural public.
Gentlemen, here again, I trust your statement on that.
Okay, this bill, being our power company people and co-ops and all are not wanting necessarily to be a provider, this is going to help the situation with some of the cable that's already buried to get the trunks to rural broadband service. Is that right?
Gentlemen, I couldn't have said that better if I'd tried to do it myself.
Thank you. You got a good bill and an amendment.
All right, I don't see any further questions.
Move final passage, Mr. Speaker.
Open the machine, Madam Clerk. Question occurs on House Bill 942. You favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Has everyone voted? Close the machine, Madam Clerk. I vote 120 yeas and 1 nay. Bill passes. Next item.
Thank you, Mr. Speaker. I'd like to go to the next item, House Bill number 5, House Bill 505. Call it up and make the usual motion.
Chairman calls the bill up, moves that the rules be suspended. Bill considered and engrossed, read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it. Gentleman's recognized.
Thank you, Mr. Speaker. Ladies and gentlemen, I'm going to be as brief as I can. I do want to make a few remarks on this one too, because this bill came about because back during the fall and summer, there were many of you that I was involved with on town hall meetings, whether they were virtual or in person. And the one resounding thing was, what can we do again, gentlemen from Washington, to get broadband out to the unserved and underserved areas, the rural areas of the state? House Bill 505 is a hybrid of several states around us, Alabama, Tennessee, Georgia, that have done a state-sponsored broadband grant program, okay? Basically, what this bill does, it establishes a grant program that sets forth the mechanism for which we could establish a grant program for broadband access across the state. Now, let me be clear on this. There's no money in this right now. This will set up the mechanism, if we pass this bill, to set up a grant program that your cities could apply for broadband grant funds, your counties could, third-party providers like your telecoms, telephone companies and places like that could apply for grants through this process. Section 1 just names the act, which is the Mississippi Broadband Accessibility Act. Section 2 does the legislative intent. Section 3 does definitions. Section 4 in this bill, I gave the public utility staff the ability to administer this program and to award these grants, and I will tell you why they've done that. I've got to give them a hand because when we gave them under Senate Bill 3064 last year, the task of getting out $130 million worth of broadband connectivity through the co-ops in a very, very short time. I'm talking about from July to December. Public utility staff did a yeoman's job of doing it. You know, down the road, if this bill goes to conference, I would like to have a little bit further discussion with the Public Service Commission about their involvement in it. But Section 4 does allow the public utility staff to establish and administer the program. Lines 86, again, defines that it, you know, should be confined to unserved areas. Basically, the language mirrors what I had in House Bill 942. No money in the fund. Lines 176 defines what projects are eligible. And that's basically the bill. There is a match on this. This grant program would provide up to a 35% of the total cost of the project. The third-party provider or your city or county would provide the rest, mirrored a lot after what these other states have done. And I've already had conversation with my county board of supervisors. They are very interested in this because in getting this out to some of these areas where it's not, if you have a $1 million project and you have $335,000 placed in it, you know, this of state money, that's a tremendous help to your counties. But it establishes a grant program. I think it's a good thing. Other states are doing it. No money in it, but here again, as we go through the process, I want to work with the chairman of Ways and Means, the chairman of Appropriations, and the Senate, and let's see what we can come up with. And I want to just directly address, I know, and this doesn't limit the technology to just fiber. I know the gentleman from Scott, he and I have had multiple conversations about some of these providers using water tanks as a fixed signal to signal. They're doing that in some areas. I know in Lauderdale County, gentleman from Lauderdale County, I think y'all have a gentleman down there that's doing some of that. It's working real well. So it would allow these people also, it's not just hitched to fiber, it's not just hitched to cable, it's hitched to any technology that entity could apply for. The public utility staff would review and award that grant. And I think it's good policy, ladies and gentlemen. Here again, I'd like for us to pass it. No money in it, but let's get the mechanism in place. And that way, if and when money does come down available through the appropriation or Ways and Means process, we'll have a mechanism in place we can hit the ground running, and that's an explanation of the bill, Mr. Speaker. I'll take any questions.
Gentleman from Lauderdale, Mr. Young.
Thank you, Mr. Speaker. Would the gentleman yield?
Yes.
Gentlemen, I'd like to go back to the original question regarding the 25 meg cap. If there are entities that would like to expand capacity in an area, would they be able to qualify for the broadband assistance grants? If they already have 25 megs in a provider and they want to go up to 100 gigabyte or whatever.
Absolutely, and that's what's the beauty of this is the public utility staff having already established and administered a program that we put on them to do under the broadband under the CARES Act, yes, there's nothing that would restrict somebody who wants to go to higher speeds in that technology if they reviewed and approved that application.
Thank you, gentlemen.
Jump from Tallahatchie, Mr. Reynolds.
Gentlemen, and I know you're probably aware, it looks like there may be a infrastructure program coming from the federal level that could be significant and could have some significant funds, probably in about 4 months, for this type of thing. For infrastructure, there will be, I am led to believe, or at least there will be an attempt to have a significant buildup in rural areas all around the United States of America. And now, gentlemen, I do think it's important that what we have, and I know you'll do it, but what we have is a framework that can serve to catch or receive available federal funds that will be coming perhaps and be adaptable enough so that when this passes, we'll be in a position to receive it and utilize it fully. As the process grows, will you work to make sure that we can receive those funds and utilize those funds and with flexibility to comply with the federal guidelines that will be attached to those funds?
Gentlemen, I will, and I'm looking for it in the bill. I'm trying to find it. I did not have that highlighted, but I think there's language in there that says that these monies that would come down from the federal government in any shape, form, or fashion could be, these entities could apply. These entities could apply for that money, depending on what the provisions of the money, what the strings attached to it are. But if they can apply for that money and use that as part of the match money, absolutely. And I will tell you, gentlemen, you've been here a lot longer than I have, but we know how technology is. It changes. I know since I've been here, I've gotten 3 laptops in the years I've been down here. So technology and all of this is changing every day. But yes, this would allow for that, gentlemen. You're exactly
Gentlemen,
right.
I think that there is a commitment to having every child and every family in this country to have in the next 4 years broadband, good, decent broadband accessibility insofar as is humanly possible.
Gentlemen, I couldn't agree with you more. And I want to say this. I had the honor of serving as wildlife chairman for 8 years. And I know this is probably not relevant to this, but I always use this, that I went from the woods to the power station. I went from the woods to the power station. So I'm learning, and I'm learning in this, but I have one goal as your public utility chairman here in the House, and that's to advance and work with you our best broadband possibilities and access to the rural areas that we can for not only the benefit of our children, but for the benefit of our families, hospitals, schools, libraries, and everything else. And no further questions, I move final passage, Mr. Speaker.
All right, I don't see any further questions. Open the machine, Madam Clerk. Question recurs on House Bill 505. You favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Close the machine, Madam Clerk. By a vote of 113 yeas and 5 nays, the bill passes. Next item. Judd B.
Thank you, Mr. Speaker. I'd call up House Bill, item number 6, House Bill 1140, and ask that you recognize the lady from Madison.
Gentleman calls the bill up, moves that the rules be suspended. Bill considered and gross read the 3rd time, placed on final passage. All in favor say aye. Opposed nay. The ayes have it. Lady from Madison is recognized.
Thank you, Mr. Speaker. Mr. Chairman, Mr. Speaker, I have an amendment.
You're recognized for an amendment.
Ladies and gentlemen of the House, amendment on line 35 after the word done and before the word by, and insert with deliberate design. Also on line 639, insert a reverse repealer for June of 2021. House Bill 1140 would amend the code section which addresses the killing of a human by adding that a person 18 years of age or older that engages in the deliberate, unlawful distribution or mixture of a substance that is proven to be the cause of death of the deceased shall be charged with first-degree murder. It also brings forward code sections for causes of death and those that provide penalties for violation of the Controlled Substances Law. We know there needs to be some adjustments to this bill, and we're sending it to conference to work out the details. That's a short and brief explanation of the bill, Mr. Speaker.
Questions on the amendment? Gentleman from Lauderdale, you have a question on the amendment?
Yes, Mr. Speaker, thank you.
Recognize.
Lady, I think you have a good amendment. My question is why restrict it to 18 and above? I was looking at the news this morning, and they are now targeting, this younger audience that's on the internet with all types of drugs. And I think that target group is going to be 18 and less that have access to buying through the internet. So my question is there a specific reason that we're utilizing the threshold of 18?
We'll continue to talk about that going forward, but 18 is the age that we try for an adult, so.
Lady from Hines, Ms. Yates.
Will the lady yield?
Yes.
I just didn't hear where your amendment inserted the deliberate language. So
It's on line 35. After the word done and before the word by, inserting the following, with deliberate design.
does the amendment make the distribution of the substance, so deliberate is required in the distribution, not in deliberately causing the death? Is that correct?
Deliberate distribution and mixing, I think is the word.
Okay.
All right, I don't see any further questions. If you favor the amendment, indicate by saying aye. Opposed, nay. Ayes have it. Anything further on the bill?
Move for final passage.
Gentleman from Madison indicates he's got an amendment. Gentleman from Adams, what purpose you seek recognition?
For question.
You yield for the question, lady.
Of course.
Thank you. I'm a little bit concerned. So we're instituting a new crime for people selling drugs, and part of the standard that you have in there is proximate cause. Now, there's very, very rarely, proximate cause is a civil cause of action, and I don't know if you know this, but it's used to describe an injury and liability. So we're inserting a tort cause of action, a tort standard of proof in a criminal case, and not just any criminal case, one in which you're charging first-degree murder. That's just a little bit extreme.
I agree with that, and that's why we're taking it to conference. This is Chairman Lamar's bill, and I appreciate this bill, but I do believe that once it's in conference, it will not be first-degree murder. I think it will be more like manslaughter. But again, I can't make that call. I'm just saying we're just going to send this to conference. We want to keep this bill alive. Just in the month of January in Oxford, Mississippi, there have been 7 overdoses and 4 deaths. That averages out a death a week. And then this past weekend, there was another death. We have to do something for our children's sake. They're mixing drugs to look like Xanax, and they're putting fentanyl in it. So we have to do something. We are all either parents or grandparents in this room, and we want to make sure that when we go home in March, that we've done something to try to keep these children alive. And no, they are making bad decisions, but we've got to help them, and we've got to make sure that the drug dealers that are dealing the drugs understand that we're serious about these crimes.
Well, has it ever been a consideration, and I appreciate that your description, you're right, we do have to do something. Whenever we talk about drug dealers, we're talking about juveniles or people who are out there selling drugs to try to do whatever they do. But we never talk about the people who are manufacturing and promoting and processing these drugs that they know are dangerous, and they make them accessible under the guise of being medicine that they know that are threatening. Is there any consideration given to the manufacturers, the pharmaceutical companies that make these drugs? Any consideration given to charging them with some high degree of liability in this type of action?
I think it's an excellent idea, but again, when we go to conference, please just get with me or whoever he sends to conference, and let's
Thank you.
put that on paper. I think that's a great idea.
Thank you.
All right, gentleman from Madison has an amendment.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, this amendment does two things. One is it inserts a confidential informant protection provision, which we've talked about in Judiciary B for many years now and just hadn't found the right bill to put it in. I'm going to read the language of that. It's relatively short. It says, confidential informants shall be at least 21 years of age and notified of their right to contact an attorney, and all notifications shall happen at least 24 hours before they agree to serve. Any deal, arrangement, or agreement must be detailed and in writing, and the constitutional right to contact an attorney shall not be abridged or undermined, and exercising that right shall incur no negative consequences on any deal, arrangement, or agreement regarding informant work. To protect the safety of the individuals involved, informants may make no more than one sale, purchase, or transfer from any individual or person. This first part of the amendment, there's two parts, but the first part is to protect people who are effectively coerced into confidential informant work. It's a problem. People get shot, people get killed, people get set on fire. Often what happens is they're doing an undercover buy, and it's as part of a deal where if they are, they're told if they make 5 drug buys or 10 drug buys that they'll get a lenient sentence. Well, if the person they're buying drugs from realizes they're wearing a wire, obviously things get ugly very fast. So there's been a lot of issues with that, and other states like Florida have adopted language similar to this, and so the first part of the amendment does this. The second part relates to the bill even more directly, which is it inserts a Good Samaritan provision in the bill. It's been the practice of this House every time a bill like this has come before the chamber to combine it with a Good Samaritan provision. And the reason for that is if you don't have a Good Samaritan provision in there, then the penalties are so high on a drug-induced homicide bill that effectively everybody flees the premises. So a Good Samaritan exception inserts these words, you have these very high penalties unless the person in good faith seeks medical assistance for the individual experiencing the overdose, transports the individual experiencing the overdose to a medical facility for care, or remains present to aid or assist in any way someone who is experiencing the drug overdose. The primary goal here is to say if somebody is overdosing, we not want people to flee the scene. We want them to call 911. We want them to stay present. And a huge issue with drug-induced homicide laws in other states is that rather than applying to drug dealers, they end up applying to whoever touched the drug last, which means they end up applying to a cousin, a friend, a relative, a best friend, which is not what the law is intended to apply to. So this makes sure that these type of laws are not applied to just who happened to touch the drug last before the person overdosed. It applies higher up the food chain to the people responsible, and there's no incentive to flee the scene and let the person die for fear of the consequence. So, ladies and gentlemen of the House, that's what this amendment does. I'm happy to answer questions.
Gentleman from Washington, Mr. Hines.
Thank you, Mr. Speaker. Gentleman, you.
Yes.
Gentlemen, so if a male and female who are in a relationship are using drugs and the female ODs and the male provides CPR or calls or tries to get them to, he is not charged culpable in her murder. Is that correct?
That is correct, gentlemen. Again, there is a very clear in good faith test. Yeah. So a judge would make the determination of was that in good faith. This is not intended to let people game the system. But yes, if a judge determines that in good faith that individual was seeking to help, then they would not be subject to this charge.
All right, thank you.
All right, I don't see any further questions. I recognize the presenter to respond, or the chairman, or somebody, anybody.
We're good with it.
All right. Question rises on amendment number 2. If you favor the amendment, indicate by saying aye. Opposed, nay. Ayes have it. Amendment number 2 is adopted. Anything further on the bill?
Move for final passage, please.
I don't see any questions. Open the machine, Madam Clerk. Question occurs on House Bill 1140. If you favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Has everyone voted? Close the machine, Madam Clerk. By a vote of 77 yeas and 42 nays, the bill passes. Next item.
Thank you, Mr. Speaker. Item number 7, House Bill 87. I would call it up, make the usual motion. Ask that you recognize the gentleman from Scott.
Gentleman calls bill up, moves that the rules be suspended. Bill considered and gross read the third time, placed on final passage. All in favor say aye. Opposed nay. The ayes have it. Gentleman from Scott is recognized.
Thank you, Mr. Speaker. House Bill 87 is a bill that's coming from the Mississippi Department of Human Services. It's for their investigators. They're asking to give their investigators law enforcement status. At the current time, these investigators already have to be law enforcement certified on the job. But what happens is they're having to work a different agency to get that certification, and we're losing our investigators there. So this bill will just allow them to be certified law enforcement officers without having to work a second job. It's supported by the Chief of Police Association and the Sheriff's Association. If there's not any other questions, I move for final passage.
Questions on the bill? I don't see any. Open the machine, Madam Clerk. Question occurs on House Bill 87. If you favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Everyone voted. Close the machine, Madam Clerk. By a vote of 107 yeas, 9 nays, the bill passes. Next item.
Thank you, Mr. Speaker. Item number 8, House Bill 188. I'll call it up, make the usual motion. Ask that you recognize the gentleman from Covington.
Gentleman calls the bill up, moves the rules be suspended. Bill considered and gross read the third time, placed on final passage. All in favor say aye. Opposed nay. The ayes have it. Gentleman from Covington.
Thank you, Mr. Speaker. House Bill 188 comes at the request of the Veterans Affairs Board. There is a unit in the corrections, I believe in Rankin County, that is for nonviolent veterans and give them certain training and things like that. This gives them some leeway regarding uniforms and what the veterans can do, and that is a description of the bill.
Questions on the bill? I don't see any. Open the machine, Madam Clerk. Question occurs on House Bill 188. If you favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Has everyone voted? Close the machine, Madam Clerk. By a vote of 119 yeas and 1 nay, the bill passes. Next item.
Pike.
Next item.
Thank you, Mr. Speaker. Item number 9, House Bill 551. Call it up and make the usual motion and ask that you recognize the gentleman from Pike.
Gentleman calls the bill up, moves that the rules be suspended. Bill considered and gross read the third time, placed on final passage. All in favor say aye. Opposed nay. The ayes have it. Gentleman from Pike to recognize.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, House Bill 551, simple bill. It amends Section 63-1-19 in order to allow the Mississippi Department of Corrections to issue a state ID to those who have been released in the last 12 months. Also have an amendment Mr. Speaker.
You're recognized for an amendment.
Okay. What the amendment does is basically it allows the department to issue those state IDs at the time of he or she's release, his or hers release from the Department of Corrections custody.
Questions on the amendment? Lady from Hines, Ms. Yates.
Can you read your amendment to me? I don't understand what exactly it's amending.
Okay. The amendment is to be inserted after line 100, and it says the Mississippi Department of Correction shall work with the department to provide an official state identification card to each person who is released from the custody of the Mississippi Department of Corrections on the day he or she is released from such custody.
Okay, so the amendment seeks to address the issue that I mentioned in committee.
That's correct.
Where the inmates are having an issue of getting a state-issued identification card because they do not have a residency, correct?
That's correct.
Okay, and the amendment is supposed to address that particular problem?
Right, well, by allowing them to receive it on the release day in the bill. Yeah, just for the inmates, yes.
Thank you.
All right, I don't see any further questions. Question occurs on amendment number 1. If you favor the amendment, indicate by saying aye. Opposed, nay. Ayes have it. Amendment is adopted.
If there's no further questions, Mr. Speaker, I move for final
Questions on the
passage.
bill? I don't see any. Open the machine, Madam Clerk. Question occurs on House Bill 551. If you favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Close the machine, Madam Clerk. By a vote of 120 yeas, 0 nays, the bill passes. Next item.
Thank you, Mr. Speaker. Item number 10, House Bill number 290. I'd call it up, make the usual motion, ask that you recognize the gentleman from Pearl River.
Gentleman calls the bill up, moves that the rules be suspended. Bill considered and gross read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it. Gentleman from Pearl River is recognized.
Ladies and gentlemen of the House, House Bill 290 is pretty unprecedented and historic for this body. It's only 1 page long, which is really interesting. It comes to us at the request of Auditor Shad White. It's very simple in that it prohibits the participation in pretrial programs for individuals who are charged with public embezzlement of an amount over $10,000. And that's a brief explanation of the bill, Mr. Speaker, and I'll yield for questions.
Questions? I don't see any. Open the machine, Madam Clerk. Question occurs on House Bill 290. If you favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Has everyone voted? Close the machine, Madam Clerk. By a vote of 114 yeas and 3 nays, the bill passes. Next item.
Thank you, Mr. Speaker. Item number 11, House Bill 300. I call it up, make the usual motion, and ask that the gentleman from Rankin be recognized to handle the bill.
Gentleman calls the bill up, moves that the rules be suspended. Bill considered and gross read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it. Gentleman from Rankin.
Thank you, Mr. Speaker. Thank you, Mr. Chairman. I have an amendment that is simply a reverse repealer.
Questions on the amendment? I don't see any. If you favor the amendment, indicate by saying aye. Opposed, nay. The ayes have it.
Ladies and gentlemen, this is a bill that is a work in progress. The problem is that the Supreme Court rules are causing people to be held in jail rather than getting them released. They could be bonding out, but instead they're being held for up to 48 hours to be able to see a judge. It's costing people their jobs and stuff. We're trying not to step on any toes, so we're being delicate with what we do with the language. So that's the...
Questions on the bill? I don't see any. Open the machine, Madam Clerk. Question occurs on House Bill 300. In favor of the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Close the machine, Madam Clerk. By a vote of 117 yeas and 0 nays, the bill passes. Next item.
Thank you, Mr. Speaker. Item number 12, House Bill 634. I call up the committee sub in lieu of the original bill, and ask that you recognize the gentleman from Wayne to handle this and the next bill. Thank you.
Gentleman calls the bill up, moves that the rules be suspended. Bill considered and gross read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it. Gentleman moves committee substitute be adopted for consideration in lieu of the original bill. All in favor say aye. Opposed, nay. Ayes have it. Gentleman from Wayne is recognized.
Thank you, Mr. Speaker. We've got a very simple amendment that was made in committee that got left out of the committee sub, and I'll let the clerk read it.
Recognize Madam Clerk to read the simple amendment.
Amendment number 1 by Representative Barnett, amend on line 150 by inserting after the word municipality the following, including but not limited to boroughs and other local government entities. Amend the title to conform.
Any questions on the amendment? Gentleman from Adams, Mr. Johnson.
Well, my question will be on the bill after
All right.
the amendment.
Any questions on the amendment? I don't see any. If you favor the amendment, indicate by saying aye. Opposed, nay. The ayes have it. Now the bill.
House Bill 634 is the preemption bill from last year that got lost in the shuffle. And this bill simply adds state agencies to the current preemption law that includes cities and counties. There is a little cleanup language in the city and county part of the statute, but the main changes are adding state agencies. It does not allow them to adopt any rule, notice, regulation, order, or policy. It also provides an avenue for relief for anyone affected by this, which would be through the circuit court. They would have to file for injunctive relief. If you'll follow me over to, I believe it's line 72, there are some exemptions to this bill. It's for state law enforcement officers to be able to exempt or adopt any policy relating to any firearm that they issue to their own officers. It allows the Commission of Wildlife to regulate the use of firearms and ammunition in the adoption of hunting seasons. And it also exempts IHL and junior colleges as long as any policy or procedure that they adopt complies with current state law. And there's also some added language, section 5, it's line 927, was requested by the Secretary of State to allow their investigators to carry firearms like the Department of Auditors. There's a couple more in that section too. Yeah, employees of the Secretary of State who are authorized by the Secretary to perform investigative or regulatory enforcement. And that's an explanation of the bill.
Questions? Gentleman from Adams, Mr. Johnson.
Thank you. Will the gentleman yield?
Yes, sir.
I just want to make sure I understand this. When you use state agencies, that's every state agencies. What about courts? Are courts considered an agency for the purpose of this bill?
Not under this bill, gentlemen.
And how do we know that?
They're not listed.
But you just say public and state agencies. Cities are considered under this bill. Is that correct?
I'm sorry. I may have misunderstood your question. Are you saying our courts exempted under this bill?
Are they exempted under this bill?
No, they are not.
Okay, so a court cannot prohibit a person under this bill from carrying a firearm into their courtroom?
In a courtroom, they can. That's already state law.
Okay, but into the courthouse, they can't?
Cannot.
They cannot. So right now, that circuit clerks, chancellors, tax assessors, tax collectors have to, they are not protected in terms of people walking into the courthouse where they have their offices carrying guns. They can't prohibit people from doing that.
I believe that's already law, gentlemen.
Well, why do we have it in here? Why are we making it a penalty? Okay, I'll try. It may be law. My next question is, so if they prohibit that carrying, now they can be assessed a penalty, like a $1,000 fine.
Correct.
And that $1,000 fine will be restricted to, say, a person on the Board of Aldermen. If he votes to impose that restriction, he could be subject to this $1,000 fine. He or she could be subject to this $1,000 fine.
Correct, gentlemen. Under this statute, if they did do that, if somebody voted to put up a sign that says no guns, and somebody were to file a complaint with the AG's office, the AG would send a letter to your Board of Aldermen stating that, hey, this is not compliant with state law. If they do not take action to correct that, that's when the fine would come in.
So private businesses like restaurants can prohibit people from bringing guns into their place of business with no fine.
Correct.
But a city can't prohibit a person from bringing a gun into a Board of Aldermen meeting.
True. That part's already state law, gentlemen.
But if they do, then that person can ask for a fine to be imposed against those who voted for that prohibition.
If they do not take corrective action, correct.
But the ones who voted to not impose the prohibition would not be liable for the fine.
Correct.
Gentlemen, we're taking it a step further to say people can carry guns, and if you tell me, no, I can't carry a gun, you'll have to pay me. That's what we're doing.
I don't take it that way, gentlemen. I think that if someone obviously and knowingly ignores state law, and they do not take the proper corrective actions. I think there needs to be some teeth in the law to get them to comply with state law.
So a board of aldermen who has their primary interest, the public safety of the people that they represent, and they impose or put a rule or a sign up that says that you can't carry a gun, even though you say that's a state law, even though there are federal laws that prohibit a lot of different agencies, federal buildings from carrying guns. So in city, hey, can I have a minute? I appreciate that. Thank you, gentlemen. Anyway, I just want to make sure that we understand that we are allowing fines to be imposed on our cities and our counties if they put up a sign that says you can't carry a gun.
It's a little bit more than them just putting up a sign. If they put up a sign and someone does file a complaint and they do not follow the law, that's when the penalty would come in.
So they can't prohibit people from bringing a gun into a board of supervisors meeting. If they do, they'll be fined.
Correct.
All right, gentlemen, thank you.
Thank you, gentlemen.
Thank you, gentlemen, I appreciate that.
The lady from Hines, Ms. Yates.
Will the gentleman yield?
Absolutely.
Tell me the impact of this particular bill on guns in schools. Will teachers be allowed to bring their guns into a classroom full of kindergarten students?
We're not changing anything about that. There's already some law, it's in the concealed carry statute about where you can and cannot carry on school campuses.
What about public universities?
They are exempted in here. It's lines,
I saw community college.
line 82, beginning on 82 through 85.
All right, so nothing, what,
And the universities provided this language. It's a compromise language that all parties have signed off on.
so under this language, can a 21-year-old college student with a concealed carry permit bring his gun onto campus legally and then use the gun illegally, potentially?
I don't believe so. It is my understanding.
You don't believe so, or that's not the case?
It is
'Cause
my
this is
understanding that is
important.
not the case. If you're enrolled in college there, they can impose further restrictions beyond this law.
What about someone who's not a student?
If they have a concealed carry permit, they can carry on campus in public areas.
What about someone who goes into a public school who's not a school teacher who has a concealed carry permit? So an angry parent.
I believe that's already law.
You believe, or it is?
It is my understanding that is already law.
I think that we need to know the answers to this specifically and not, I believe, before we pass something like this. I maybe am the only one in here who has lived through a school shooting. So things like this matter. I have a kid who's in kindergarten now. These things matter. And I think that we need to make sure that we're addressing these things properly on the front end before we pass a bill that you don't think impacts any of this.
Thank you, lady.
Gentleman from Hines, Mr. Bell.
Thank you, gentlemen. You?
Yes, sir.
So my concern, like my desk mate, you're allowing, with this piece of legislation, to have individuals to walk in courthouses, courtrooms, city agencies, city buildings, with their firearm. What is the assurance that a domestic terrorist situation wouldn't occur with respect to this bill, like they did in Washington a couple of weeks ago?
Gentlemen, there's no way we can predict when or where that type of behavior will occur.
I agree, but wouldn't you agree with me that this would only make it easier for something like that to happen?
I don't. I think that having more armed, legally law-abiding citizens would prevent such instances.
All right. Thank you, Jim.
Yes, sir.
Gentleman from Madison, Mr. Blackman.
Thank you, Mr. Speaker. Gentleman, yeah.
Yes, sir.
This bill has in it also a provision that will prohibit buyback programs by municipalities or county government.
Correct.
What's the reason for that?
Gentlemen, I think that, and we've looked at a number of studies that show that those programs are, they're not successful.
What study is that?
Sir?
What study is that you're referring to?
I've seen numerous. I mean, we've looked at things that, you know, if somebody's got a gun they're planning on committing a crime with, they're not going to go turn it in for $50. The ones you get are old heirloom firearms that have been handed down to kids that you know, got granddaddy's old shotgun that don't think they're ever going to hunt. Those are not the people that are going to commit crimes. The people that are going to commit crimes are going to do it regardless. These gun buyback programs just simply don't work.
Well, of course, I would ask you where you're getting that information from, but I'd rather ask you this question. What harm is it then if someone has an old heirloom, an old gun, you refer to it, and the city, as exercises its policymaking authority, wants to buy those guns? What harm is that to anybody?
I think it's the use of public tax dollars to do that is where the issue comes in, gentlemen.
But we here are now saying that we can determine better what a local government should do on its policymaking authority with reference to how it governs among the people who have elected them.
Again, gentlemen, it's their effectiveness combined with the use of tax dollars is where this was targeted.
All right, look, and I speak with some knowledge about this because Canton, under one of the wishes of one of his former chiefs of police, had what they thought was a very effective buyback program, and it wasn't old heirlooms that were bought back. These were guns that were bought back by primarily young people that bought and sold them for whatever reason in an effort to reduce the presence of guns in that community. Don't you see that as being a concern, a legitimate concern of the local government who would know better what's best for their community than we down here at the Capitol?
Gentlemen, I'm going to disagree with you on that. I do think that it could also lead to further, you know, instances where young kids would break into vehicles to steal guns just to be able to turn them in at these programs.
No, they had to be verified. They couldn't just walk in and hand out a gun. From the program that I'm aware of, you had to show that you had legitimate ownership of the weapon. And if you did walk in with a stolen weapon, you went to jail.
I've seen the other side of that too, gentlemen.
Where? Tell me where you've seen that at.
Just news stories that I've looked up on the internet. I mean, you can research gun buyback programs and.
Give me the website you're talking about.
Gentlemen, I don't have that in front of me.
All right.
Gentleman from Pike, Mr. Porter, passes. Gentleman from Warren, Mr. Denton.
Thank you, Mr. Speaker. Gentleman, will you yield?
Yes, gentlemen.
You know I have some concern over about this bill because I spoke to you about it earlier. Is there any place that a law-abiding citizen that has a concealed carry permit can enter into a public building with a gun? Is there any place right now that you know of that a person can or cannot enter into a public building with a firearm?
So in the concealed carry statute, it does list, you cannot go into sheriff's office, highway patrol stations, courtrooms, non-public places in these public facilities. Gentlemen, I'd be glad to look up that language if you'd like a definitive list, but there are some places.
I think we need to, this body needs to know that is this building right here that we're in right now today, where would we stand if this law passed? Where would this body stand if this law passed? Can anyone enter into this building with a firearm?
Gentlemen, this bill does not address that.
But can they do it though?
I don't believe so. I think that the House rules or the joint rules would supersede that.
So we can create rules that govern us and protect us, but a municipality cannot create a rule to protect them. Is that what you're telling me, gentlemen?
Gentlemen, if you want to have that fight, I'll be glad to have it with you, but this bill does not address that.
But is that what you're telling me? I mean, it's either yes, that's what I'm saying, no, that's what I'm not saying. I mean, it's just that simple.
Gentlemen, this bill it does not address that.
Gentlemen, this is a bad bill, and I hope this body will vote against this bill. We are opening up the doors. Well, the door is already open, but we're swinging it wide open for something to happen down the road. Thank you.
Thank you, gentlemen.
Gentleman from Holmes, Mr. Clark.
Thank you, Mr. Speaker. Would the gentleman yield?
Yes, gentlemen.
Gentlemen, I wasn't going to ask any question, but I want to follow up from the gentleman from Warren, and then which he was speaking about the Capitol. But as I read the bill, it speaks of state agencies, and then it has some exceptions to which state agencies. Now I want to briefly talk about DFA, Department of Finance Administration. So right now, if you go across the street to the Silas building, you have Capitol Police out there, and which is not governed by the joint rules of the House or the Senate. So would this piece of legislation apply to the Silas building?
I believe so, gentlemen. Yes.
So right now, they would have to get rid of the metal detectors and all of that over there and allow free access to go in with guns.
Correct.
Okay. Across the street at the Woodfall building, well, I guess that's also DFA, so that would also apply to the Woodfall building.
Correct.
Department of Transportation, the governor's mansion, when at the end of COVID, which is also, correct me if I'm wrong, is controlled by DFA. So when they start back giving tours at the governor's mansion, they could go in with firearms.
I don't think so, gentlemen, because that is not a public area. That is a private residence.
Private residence?
It's not accessible to the public.
At one time, they was giving tours there. Assuming they go back to giving tours and start opening it up to the public for the purpose of touring it, would you think that they would be allowed to carry firearms in the governor's mansion?
If they have a permit, I would be okay with that.
Okay. And I agree with the gentleman from Warren. I go back to why are we exempt here at the legislature? I think, you know, we should go first. We should change our rules here at the House and allow firearms up in that gallery before we tell municipalities where the rubber meets the road, where people get upset about garbage and police and everything else. Gentlemen, I just think this is a step too far. Thank you, gentlemen.
Thank you, gentlemen.
Gentleman from Washington, Mr. Hines.
Thank you, Mr. Speaker. Gentleman, you.
Yes, sir, gentlemen.
Gentlemen, let me play out this scenario for you. Board of Supervisors impose a ordinance to remove all abandoned or non-running vehicles off of property and for public health's sake. And there's a disgruntled resident, and he comes to the courthouse to present himself with his disgust about this particular policy statement. And he is known to be kind of like Ernest T. Bass mentality. You know, I'm gonna get you, I'm gonna get you, I'm gonna get you. And they have removed all the metal detectors, they removed all the things in place for the board. It's an open boardroom. What happens if this man with the Ernest T. Bass mentality walks in there and starts shooting? What happens then?
Gentlemen, I would offer to you that if he thinks that there may be a good guy with a gun in there, he's a lot less likely to open up shooting.
So it is not the responsibility of those board members of that county to have firearms on them to protect themselves. It is the responsibility of that unit of government to protect those supervisors. Would you not agree with me?
Gentlemen, I don't. I think we're going to disagree on that.
Okay. Gentlemen, are you a lawyer?
I'm not.
Okay. So you wouldn't know what it feel like to be inside a courtroom and have an angry parent or husband upset with someone who has raped or abused their child and feel like justice has not been served. You wouldn't know how that feel, would you?
I would not.
So if that individual had free reign in the courthouse, a time to kill scenario, so to speak, would that be, could that possibly happen under this piece of legislation?
Gentlemen, that's already state law. This does not address that.
Okay. What it does address is that if a board or a board of aldermen or a board of supervisors decide that they want to impose safety measures for their employees in a particular building, and they set a policy up, and somebody who gets mad because they can't go in there and do what they want to do, files a complaint, all those aldermen or board or supervisors or city council persons can be fined. Does that do that, yes or no?
If they do not take corrective action, yes.
Okay, so where does public safety supersede this foolishness?
Gentlemen, I would submit to you at the Second Amendment.
Okay, so what you're saying is you just don't care. We're going back to the OK Corral scenario. Everybody bring their gun. We have a dispute. Let's shoot. It don't matter. That's what you're saying, ain't it? Is that not what you're saying?
I just want those fellas to follow the state law. That's all.
So what's wrong with the law now? Tell me what incident has taken place that make this a necessity or a need right now. Give me a list of them. Because you said you had a list of some other stuff that happened. You got a list of anything that has gone wrong with the way the law is currently set now.
I do, and the gentleman from Holmes just listed them. MDOT, the Sillers Building. We've got a number of state agencies that continually do not follow this law.
So you're saying that providing public safety is a violation of this law. That's what you're saying?
Gentlemen, I'm not. That's what you're saying.
No, I'm asking you a question. Because if right now, if an individual wanted to go inside of DFA, the Sellers Building, or what a Supreme Court just entered them, and had a gun on them, they couldn't get in. Is that correct?
I'm sorry. Restate the question.
If an individual wanted to go into the Sellers Building or what a Supreme Court justice entered them with a weapon on them, they could not get in. Is that correct?
Correct, right now.
Okay. What is wrong with that?
Well, gentlemen, I think with that being public property of this state, I don't think that they should be restricted from carrying a firearm in that building.
Okay, so let me ask you this question, and I'm about to be through. Just like what happened to us, we filed a lawsuit. The Supreme Court ruled against this body. What will stop one of the individuals from this body walking across the street, walking up those stairs, inside their doors, and shooting the Chief Justice for not ruling in his favor? Under your scenario, that there's a public building, I can walk in there, could that possibly happen under this scenario?
Gentlemen, if they're not going to stop under the rest of the laws that they violated to do that, I don't think this law is going to matter either.
So you just don't care about how people live and survive?
That's not my words, gentlemen.
Okay.
Gentlemen. Okay.
Move final passage.
All right, gentlemen, yields a podium. Question occurs on House Bill 634. Open the machine, Madam Clerk. If you favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Everyone voted. Close the machine, Madam Clerk. By a vote of 78 yeas, 40 nays, the bill passes. Next item.
Thank you, Mr. Speaker. Item number 13, House Bill 5. Call up the committee sub, make the usual motion, call up the committee sub, and ask that again yield to the, recognize the gentleman from Wayne.
Gentleman calls the bill up, moves that the rules be suspended. Bill considered in gross read the third time placed on final passage. All in favor say aye. Opposed nay. The ayes have it. Gentleman moves committee substitute be adopted for consideration of the original bill. All in favor say aye. Opposed nay. The ayes have it. Gentleman from Wayne is recognized.
Thank you, Mr. Speaker. This is a much less controversial issue. This is the hazing bill that was passed last year. It's much the same form. I believe the major changes start on line 127. There's a first and a second degree that's not changed much. The big change in this bill starts on line 153. It simply adds third degree, which covers the forced or coerced alcohol consumption that results in the victim having a blood alcohol concentration of at least 30%. This creates the penalty of a felony up to $10,000 fine and up to 5 years in prison. I'll take any questions.
Questions on the bill? I don't see any. Open the machine, Madam Clerk. Question occurs on House Bill 5. If you favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Everyone voted. Close the machine, Madam Clerk. By a vote of 89 yeas, 28 nays, the bill passes. Next item.
Thank you, Mr. Speaker. I'm going to ask that we pass item 14 and it remains its place on the calendar.
Any objection? Okay, we'll do that. Next item.
All right, item 15, House Bill 196. I'll call it up, make the usual motion.
Chairman calls the bill up, moves that the rules be suspended. Bill considered in gross read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it.
Thank you, Mr. Speaker. Ladies and gentlemen, I was just telling legal counsel, this perhaps is one of my favorite bills that we've taken up since I've been here. This is called the Dignity of Incarcerated Women Act. And basically what we're saying is a number of things, but for the most part, I think currently there are about 4 women who are incarcerated in our prisons. And this is providing those women with some dignity, I guess, being incarcerated. For example, we are preventing the Department of Corrections from restraining a pregnant woman while she is incarcerated and up to 30 days after delivery, unless it is deemed by the Department of Corrections that she will harm herself, that she would harm the baby or someone else, or if she's a flight risk. If those things are present, then of course the Department of Corrections has the authority to restrain them. But in any event, if they are not going to be restrained. There are no restraints while there is labor, unless those 4 factors are there. There is no faculty employee other than a certified health official can do any type of body search or any type of strip search, if you will, on a pregnant woman. The DOC also ensures that a pregnant inmate is given the proper food, proper dietary supplements for her pregnancy. Cannot be placed in any type of restrictive housing also on that. And postpartum care, we were addressing postpartum care. Right now, it's my understanding if a baby is born in the Department of Corrections, that baby is immediately removed from the mother. We're going to say, no, we're not going to do that. We're going to allow the baby to at least stay with the mother for the first 72 hours after birth. I think studies have shown that the baby does better with that. It's a health issue for the baby. And again, we understand that the mother is there for some reason, but the child shouldn't be penalized for the bad choices of the mother in this regard. Also, to the extent that MDOC is able, even mothers who have children that were not born in jail, to the extent that MDOC is able, we're going to try to keep mothers within a 250-mile radius of their young children and allow those children to meet, give them the ability to meet for at least 2 times a week if they're able. Again, trying to keep a family relationship together. Let me see. We're going to limit inspections by male guards, and the guards and employees there at MDOC have to go through some additional training for women and know what their health needs require. And we're going to provide whatever feminine hygiene products that are there, the MDOC must provide those. And again, like I said, training and technical assistance, and limit inspections by male guards. Ladies and gentlemen, this is a bill that addresses what I think is one of the core principles of government, and that is protecting life. And this is, in my view, one of the most pro-life bills that we've passed out of here. We are protecting these unborn children who are in a situation that they didn't ask for, and I think it's incumbent upon us to do that. And with that said, Mr. Speaker, I will answer any questions and move for final passage.
Questions on the bill? I don't see any. Open the machine, Madam Clerk. Question occurs on House Bill 196. If you favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Close the machine, Madam Clerk. By a vote of 115 yeas and 0 nays, the bill passes. Next item.
All right, thank you, Mr. Speaker. I'll call up House Bill, item number 16, House Bill 163. I'm going to call up the committee sub, and I want to table that committee sub, Mr. Speaker.
Gentleman calls the bill up, moves that the rules be suspended. Bill considered engrossed read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it. Gentleman moves to table the committee sub. Those opposed have 5 minutes. Any opposed? I don't see any. Motion is to table. All those in favor say aye. Opposed, nay. Ayes have it. We're back to the original bill.
We do have an amendment? Yes, because it has some stuff in there that had this section 1 that I want out. Okay. And then we're going back to just to code section 4.
Just bring this up and
Mr. Speaker, we're back on the original bill, is that correct?
Yes, sir.
Okay. Yeah, just offer the amendment, tell them we're going to take out that and then get back on the original bill. Back on the
Gentleman Mark Kirby Hall presenting the bill.
Yes, sir, sorry.
All right, you recognize, gentlemen.
Thank you, Mr. Speaker. I have an amendment at the appropriate time.
You're recognized for your amendment.
We could have her read the amendment, Mr. Speaker.
Recognize Madam Clerk to read the amendment.
Amendment number 1 by Representative Robertson and Bain, amend by deleting section 1 in its entirety and renumber the succeeding sections. Amend further on line 881 after 2021 before the period by inserting the following, and shall stand repealed on June 30th, 2021.
Any questions on the amendment? Gentleman Prentice, Mr. Arnold.
Thank you, Mr. Speaker. Gentleman Yule.
Yes, sir.
Gentlemen, there's no language in here to do anything to our judicial districts, correct?
No, sir. What we have here today is exactly what the law is today, except for making the amendment for a repealer.
So why are we passing something that's exactly what the law is today, except for a repealer?
Because we're trying to continue working on it in the future. The intent here is to keep this bill alive so that there's a mechanism to keep operating in the future with that particular section.
Gentlemen, is the code section still in that piece of legislation to expand the judicial districts of our state?
Yes, sir. That is true, what you just said.
Okay, and a repealer in it means it'll probably go to conference, correct?
Yes.
And when it comes from conference, what does that mean? Anything could be added to the bill in conference, correct?
Absolutely.
And at that
or taken away.
And at that point in time, it'll just be an up or down vote. No amendments could be added, correct?
Yes.
I want to speak against the bill, Mr. Speaker.
Your bill or the amendment?
Well,
on the amendment right now, gentlemen.
On the amendment. I'll just hold at this point.
Gentleman holds. All right. Any other questions on the amendment? I don't see any. If you favor the amendment, indicate by saying aye. Opposed, nay. Ayes have it. Amendment is adopted. Anything further on the bill? I don't see any. Open the machine, Madam Clerk. The question occurs on House Bill 163. If you favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Has everyone voted? Close the machine, Madam Clerk. By a vote of 56 yeas and 59 nays, the bill fails. Next item.
Mr. Speaker, I'd like to hold that last one on a motion to reconsider.
All right. Everybody's holding. There's a song about that. Know when to hold up, fold up, know when to hold them. Something like that.
Yes, yes. We're giving DAs what they want.
Know when to walk away. Know when to run.
All right.
Never count your money when you're sitting on the table. Time enough for counting when the dealing's done. You ready yet? I'm gonna start singing.
Yes, Mr. Speaker, we're ready.
All right.
Item number 17, House Bill number 286. Call it up, make the usual motion.
Gentleman calls the bill up, moves that the rules be suspended. Bill considered engrossed, read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it. You recognize.
Thank you, Mr. Speaker. House Bill 286 is a simple bill. It allows for giving authority to people who own, to agencies, entities that may own a cemetery or some type of funeral home, the ability to inter or disinter human remains pursuant to written instructions signed by and acknowledged by the next of kin. Apparently, this is an issue that's coming up where there's not been notice to some people who have, to some family members who have had others that have been interred. We're just given the authority of them to do that. It is, the priority is laid out as next of kin. It begins with the spouse, then it goes to children, then it goes to parents, then it goes to siblings. There is a mechanism in place if there is a disagreement between, say, two children of a deceased. There's a mechanism that allows for the entity to follow and know which way, and provide them with guidance to know whether they need to disinter the body or not. All of the expenses are usually borne by the next of kin unless there's a court order that says otherwise. We're also amending the autopsy section allowing for disinterment in accordance with this act, meaning that in order to be disinterred, you have to notify the proper family member. Also, there's ability for a cemetery owner to correct an error. I've handled cases like this before when someone was buried in the wrong place and we had to jump through some hoops to do so. This hopefully corrects that policy and allows for again, the cemetery owner to have some guidance on what they can do. It incorporates some of the principles that were enumerated by the Mississippi Supreme Court in Hood versus Spratt. It's also similar legislation that was enacted in Tennessee, Missouri, and in Louisiana. And if there are no questions, Mr. Speaker, I'll move for final passage.
Gentlemen, could this bill have grave consequences?
Absolutely.
I don't see any questions. Open the machines, Madam Clerk. Question occurs on House Bill 286. If you favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Everyone voted. Close the machine, Madam Clerk. By vote 113 yeas and 0 nays, the bill passes. Next item. Judiciary A.
Thank you, Mr. Speaker. I'd like to go to item number 18, House Bill 352. Call it up and make the usual motion.
The lady calls the bill up, moves that the rules be suspended. Bill considered engrossed, read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it. Ladies recognized.
Mr. Speaker, will you please recognize the gentleman from Lafayette to present the bill?
Gentleman from Lafayette.
Thank you, Mr. Speaker, Madam Chair. House Bill 352 is a bill that will require background checks for Mississippi home inspectors. This is a bill we passed last year with 117 votes. Home inspectors, realtors, and appraisers are all under the jurisdiction of the Real Estate Commission. Background checks are required for the realtors and appraisers now, and this would just align the home inspectors with the realtors and appraisers.
Questions on the bill? I don't see any. Open the machine, Madam Clerk. Question occurs on House Bill 352. If you favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Has everyone voted? Close the machine, Madam Clerk. By vote 111 yeas and 4 nays, the bill passes. Next item.
Thank you, Mr. Speaker. I'd like to go to item number 19, House Bill 1012. Call it up and make the usual motion.
The lady calls the bill up, moves that the rules be suspended. Bill considered engrossed, read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it. Ladies recognized.
Mr. Speaker, please recognize the gentleman from Lafayette to present the bill.
Gentleman from Lafayette recognized.
Thank you, Mr. Speaker. House Bill 1012 comes to us from the Secretary of State. It is a bill that defines a charitable organization and for the exemption of religious institutions. The exemption requires the entity to primarily be supported by governmental grants, contracts, funds solicited from their own membership. We're removing the language of previous donor. This language has been used as an attempt by unqualified entities to claim this exemption. And then in Section 511, the charitable acts is provided for out-of-state entities. This will add language for in-state entities for reporting mechanisms as well. That's an explanation of the bill.
Questions on the bill? I don't see any. Open the machine, Madam Clerk. Question occurs on House Bill 1012. If you favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Close the machine, Madam Clerk. By vote 117 yeas, 0 nays, the bill passes. Next item.
Thank you, Mr. Speaker. I'd like to go to item number 20, House Bill number 1078. Call it up and make the usual motion.
Lady calls the bill up, moves that the rules be suspended. Bill considered in gross read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it. Ladies recognized.
Mr. Speaker, please recognize the gentleman from Lafayette to present the bill.
Gentleman from Lafayette.
Thank you, Mr. Speaker, Madam Chair. Again, this one is from the Secretary of State's office as well. It's providing, they have regulatory oversight on various industries. This one would add oversight for pre-need and perpetual care portions of the code, which is requested by the Secretary of State. That's the explanation of the bill.
Questions on the bill? I don't see any. Open the machine, Madam Clerk. Question occurs on House Bill 1078. If you favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Close the machine, Madam Clerk. By vote 113 yeas, 0 nays, the bill passes. Next item.
Thank you, Mr. Speaker. I'd like to go to item number 21, House Bill number 1181. Call it up and make the usual motion.
The lady calls the bill up, moves that the rules be suspended. Bill considered in gross read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it. Ladies recognized.
Mr. Speaker, please recognize the gentleman from Lafayette to present the bill.
Gentleman from Lafayette is recognized.
Thank you, Mr. Speaker. Madam Chair, House Bill 1181. Last one comes from us from the Secretary of State. This is asking that when you register a business with the Secretary of State, you also add an email address. This doesn't change anything currently, but filings moving forward, you'd be required to add an email address. That's an explanation of the bill.
Questions on the bill? I don't see any. Open the machine, Madam Clerk. The question occurs on House Bill 1181. If you favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Close machine, Madam Clerk. By a vote of 117 yeas, 0 nays, the bill passes. Next item.
Mr. Speaker, I'd like to go to item number 22, House Bill number 631. Call it up and make the usual motion.
The lady calls the bill up, moves that the rules be suspended. Bill considered in gross read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it. Ladies recognized.
Thank you, Mr. Speaker. Mr. Speaker, ladies and gentlemen of the House, House Bill number 631 is a bill that the House passed overwhelmingly last year. It allows off-duty use of official vehicles while performing security services in off-duty hours by law enforcement officers. And this was a bill that was requested by our law enforcement officers last year and again this year. We passed it overwhelmingly, like I said, last year, and then it died during the pandemic while we were in conference. So it was a request to revive it again this year. And I do have an amendment at the appropriate time, Mr. Speaker, that I'd like to propose to this bill.
Okay, you're recognized.
Mr. Speaker, ladies and gentlemen of the House, the amendment just says that if the person or entity or the person's or entity's insurer fails or refuses to endorse, indemnify, or hold harmless the employing jurisdiction shall not approve the use of any official uniform, weapon, or vehicle of the employing jurisdiction for private security services. And that's an explanation of the proposed amendment. Mr. Speaker, I'll yield for any questions.
Questions on the amendment? Gentleman from DeSoto, Mr. Hopkins.
Thank you, Mr. Speaker. Lady, will you yield?
Yes, of course.
I think your amendment just fixed the problem I had with this bill. So we're putting the responsibility, the insured responsibility back on, let's say, a church that these people are doing security for. So we're putting that back on them for the responsibility of any damages.
Right, and if the entity's insured fails or refuses to indemnify or hold harmless the imploring jurisdiction, then the imploring jurisdiction shall not approve the use of any uniform, vehicle, or weapon. You're exactly right.
Okay. Thank you, ladies. It's a good amendment.
You're welcome.
Don't see any further questions. Oh, excuse me, there is one. Gentleman from Hines, Mr. Brown.
Madam, you yield, please.
Of course.
Thank you. I had a concern, as the gentleman just spoke from a moment ago, about the liability situation. But how can you guarantee, so to speak, that the entity that the off-duty officer will be engaged with does in fact have the proper liability insurance to indemnify the losses if they take place? How can you be assured? The bill doesn't say anything about showing documents or that the entity presents the document substantiating the fact that they do in fact have liability or errors and omissions and what have you.
Well, I think that the county or the municipality, gentlemen, that attorney, for instance, I represent municipalities. I think that attorney.
Well, no, I'm saying that the.
Hold on, gentlemen.
The off-duty.
Hold on. You asked me a question, let me answer.
Well, I mean, but you were going at it the wrong way, I think.
No, gentlemen, I'm answering your question.
Excuse me, gentleman. Lady has a right to answer. You're recognized, lady.
Thank you. So your question was, how can you ensure that the officer is going to have insurance?
No, I didn't ask that.
Okay, well, what's your question, gentlemen?
I said the entity that the officer is going to work for in his off-duty capacity. How can you be assured that they in fact have the liability insurance necessary to cover a loss if it occurs? In other words, do they have to show a document? Do they have to show their policy? Just how can you be assured that they have the proper liability coverage?
All right, so I'm glad that you asked your question again, because both of us don't need to be confused. And so the way the bill is written, gentlemen, is that, for instance, if the officer wants to engage and use his weapon, his vehicle, his uniform, etc., because I've actually had instances where this happens, then you would just go and you put it on your minutes, spread it on your minutes, etc. And so if you're inquiring, and again, I'm not sure, maybe I'm understanding your question, but if you want to make sure that there is insurance in place, I think that this amendment covers it. The gentleman from DeSoto just asked, well, what if you don't have insurance? Well, the amendment says if you don't have insurance, then you shall not approve of any official uniform, weapon, or vehicle. And so that's the sole purpose of having the amendment, gentlemen.
Gentleman from Fayette, Mr. Williamson.
Lady, do you yield?
Oh, you're all the way over there. Thank you. Yes.
So I'm just looking, and tell me if I'm wrong, I'm looking at it from two perspectives, from the taxpayer and the law enforcement officer. I want to make sure both, or at least one, benefits. But from the taxpayer's perspective, it's costing us money to maintain and use and wear and tear on the vehicle. From the law enforcement officers, I want them to benefit in some way. Obviously, they're...
Excuse me, gentlemen. Lady's time has expired on the amendment. All right. Question now recurs on Amendment 1. If you favor the amendment, indicate by saying aye. Opposed, nay. Ayes have it. Amendment is adopted. Anything further on the bill? I don't see any further questions. Open the machine, Madam Clerk. Question occurs on House Bill 631. If you favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Close the machine, Madam Clerk. By a vote of 112 yeas and 4 nays, the bill passes. Next item.
Mr. Speaker, I'd like to go to item number 23, House Bill number 695. Call it up and make the usual motion.
The lady calls the bill up, moves that the rules be suspended. Bill considered and gross read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it. Ladies recognized.
Thank you, Mr. Speaker. Mr. Speaker, ladies and gentlemen of the House, House Bill number 695 is a bill that we passed last year again. This bill has been requested by our domestic violence shelters here in the state of Mississippi, and all it simply does is remove the matching funds requirement for the state domestic violence fund. And that's an explanation of the bill. Mr. Speaker, I'll yield for any questions.
Gentleman from Fayette, Mr. Williams.
Mr. Speaker, that was from the last bill.
Oh, okay. All right, I don't see any questions. Open the machine, Madam Clerk. Question occurs on House Bill 695. You favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Has everyone voted? Close the machine, Madam Clerk. By a vote of 116 yeas and 0 nays, the bill passes. Next item.
Mr. Speaker, I'd like to go to item number 24, House Bill number 277. Call it up and make the usual motion.
Lady calls the bill up, moves that the rules be suspended. Bill considered and gross read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it.
Mr. Speaker, will you please recognize the gentleman from Forest to present the bill?
Gentleman from Forest, recognized, present the bill.
Thank you, Mr. Speaker, and thank you, Madam Chair Lady. What House Bill 277 does, it creates and gives legal status and validity to tribal identification cards. The tribal identification card is defined at line 69 through 72, and it's an identification card that is a valid identification card issued by a federally recognized Indian tribe that contains a color photograph of the card holder and the card holder's legal name, address, and date of birth. It just places that card at the same level as a driver's license, a state-issued ID, and other identification that is already recognized. Mr. Speaker, that's an explanation of the bill, and I'll answer any questions that members may have.
Questions on the bill? I don't see any. Open the machine, Madam Clerk. Question occurs on House Bill 277. If you favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Close the machine, Madam Clerk. By a vote of 119 yeas, 0 nays, the bill passes. Next item.
Mr. Speaker, I'd like to go to item number 25, House Bill number 299. Call it up and make the usual motion.
Lady calls the bill up, moves that the rules be suspended. Bill considered and gross read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it. Ladies recognized.
Mr. Speaker, will you please recognize the gentleman from Tallahatchie to present the bill?
Gentleman from Tallahatchie recognized for a brief explanation of the bill.
Mr. Speaker, I'll be very brief. This is something that I have seen and the lady has seen and all of us small town folks have seen. This would establish that when you've got a conveyance to husband and wife and the property is the primary residence of the married couple, it would create a rebuttable presumption that that property was intended to be property with joint tenancy with right or survivorship. All too often now I'm seeing people that don't use a lawyer or others that have a Zoom deed from Tennessee or somewhere and they presume that it creates the tenancy with right or survivorship. It does not. And as a result, when daddy dies, mama's left with the property and other children say, I ain't gonna let mama bar against it. So you've got a mess on your hands. This just does what the parties want to do, are intended to do, and if they do contrary language in, it won't happen. but this is just clean up language and try to make things simpler and do what the parties think they were doing.
Questions? Jump from Calhoun, Mr. Beckett.
Just a couple questions with the gentleman yield. I think you answered one of those. If it's clear in the deed that they want to be tenants in common, then that will prevail.
Gentlemen.
All right. And the other thing is, if I acquired my house before I got married, this wouldn't change that in any way.
No, sir. No, sir.
Okay. Thank you.
Lady from Hines, Ms. Yates.
I have just a technical application question. The bill states that this will be effective from and after July 1st, 2021. So does that mean that this will apply to deeds that are filed after July 1st, 2021? Or does this mean that it will apply to deeds that are questioned or challenged in probate after July 1st,
Lady,
2021?
I think it would apply to those deeds that are done after that date, is how I think that would work.
Are we sure?
I'm not, the court hasn't ruled on that, but I believe it would have prospective effect. If it had retrospective effect, it'd be all right with me, but I believe it'll have prospective effect.
Okay.
All right, I don't see any
I wish
further
it did have
questions.
retroactive.
Open the machine, Madam Clerk. Question occurs on House Bill 299. If you favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Closed machine, Madam Clerk. By a vote of 118 yeas, 0 nays, the bill passes. Next item.
Thank you, Mr. Speaker. I'd like to go to item 26, House Bill 746. Call it up and make the usual motion.
The lady calls the bill up, moves that the rules be suspended. Bill considered in gross read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it. Ladies recognized.
Thank you, Mr. Speaker. Will you please recognize the gentleman from Forest to present the bill?
The gentleman from Forest is recognized.
Thank you, Mr. Speaker and Madam Chair Lady. House Bill number 746 is the work product of the Mississippi Automobile Dealers Association, the Alliance for Automotive Innovation, Gulf States Toyota, General Motors, and Nissan. When we purchase an automobile, every new automobile has a warranty connected with it. When there's a defect in the purchased automobile, we return this automobile generally to the dealer where we purchased it, and the dealer performs the necessary repair work on it and actually doesn't charge us anything because we've already paid for it. What this bill does, House Bill number 746, it changes the reimbursement arrangement policy between the dealer and the manufacturer, and basically puts the dealers in Mississippi at the same level as the dealers in 46 other states. So it basically puts Mississippi on the same status as the dealers in 46 other states, and certainly provides and improve the relationship for our automobile dealers. Mr. Speaker, that's an explanation of House Bill number 746, and I'll answer any questions that members may have.
Questions on the bill? I don't see any. Open the machine, Madam Clerk. Question occurs on House Bill 746. You favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Close the machine, Madam Clerk. By a vote of 116 yeas and 2 nays, the bill passes. Next item.
Thank you, Mr. Speaker. I'd like to go to item 27, House Bill 932. Call it up and make the usual
The
motion.
lady calls the bill up, moves that the rules be suspended. Bill considered in gross read the third time, placed on final passage. All in favor say aye. Opposed, nay. The ayes have it. Ladies recognized.
Mr. Speaker, will you please recognize the gentleman from Tallahatchie to present the bill?
The gentleman from Tallahatchie is recognized.
Mr. Speaker, ladies and gentlemen, this bill would simply revise provisions of child support law to comply with the Federal Consumer Protection Act. This is a requirement of federal law, and it primarily deals when lump sums are received, and it requires the federal language for distribution of lump sums when those come in. And so that's all it does, is to comply with federal law, which we have to do. So I move that it
Questions on
passes.
the bill? I don't see any. Open the machine, Madam Clerk. Question occurs on House Bill 932. If you favor the bill, vote aye. If you're opposed, vote nay. Has everyone voted? Everyone voted. Close the machine, Madam Clerk. By vote 117 yeas, 0 nays, the bill passes. Announcements, Mr. Clerk. Announcements, Madam Clerk. Announcements by the members. Lady from Pearl River, Ms. Wilkes. Hold on, lady. Try it now.
Thank you, Mr. Speaker. I'd like unanimous consent to change my vote from no to yay, nay to yay on House Bill 188.
Any objection? Change the lady's vote. Gentleman from Lee, Mr. Thompson. Hold on, gentlemen.
All right.
Try it now.
Thank you, Mr. Speaker. I'm asking for unanimous consent to change my bill on House Bill number 5 from yay to nay. Also my desk mate.
Any objection? Change the gentleman's vote. Gentleman from Lee, the gentleman from Marshall, that desk mate? Thank you. Gentleman from Montgomery, Mr. Oliver. Try it now.
Thank you, Mr. Speaker. Mr. Speaker, on House Bill, on page 2, item 2, House Bill 525, I erroneously misvoted my seatmate. With unanimous consent, I would like to have her vote changed from yay to nay.
Any objection? Change the vote. Gentleman from Neshoba, Mr. Bounds.
Speaker. Thank you, Mr. Speaker. Unanimous request to change my vote on item number 16, House Bill 163, from no to yes.
Any objection? Change the gentleman's vote. Gentleman from Hines, Mr. Bell. Gentleman from Hines, Mr. Bell.
Oh, I'm sorry, Mr. Speaker. Mr. Speaker, I'd like to hold item number 12, House Bill 634 on a motion to reconsider.
Okay, we will do that. Lady from Hines, Ms. Foster.
Thank you, Mr. Speaker. I would like unanimous consent to change my vote on House Bill 634 from yes to no.
Any objection? Change the lady's vote. Lady from Harrison, Ms. Crawford.
Request unanimous consent to change my vote on House Bill 87, number 7, from yes to no.
Any objection? Change the lady's vote. Gentleman from Smith, Mr. Tullis.
Mr. Speaker, are we fixing to adjourn for the day?
Yes, sir.
I have two adjourning memories. The first one is our Circuit Judge, Eddie Bowen, who died of COVID this past Sunday. And the second one is a young lady from Smith County who was struck and killed on the interstate in Lincoln County, Miss Allison Berthollet.
Thank you, sir. We will do that. Gentleman from Lauderdale, Mr. Young.
Thank you, Mr. Speaker. I do not request to change my vote.
Good.
I would like to hold item number 12, House Bill number 634 on a motion to reconsider, please, sir.
It's already been done, gentlemen.
Already done. Thank you, sir.
All right. Any further announcements by any member? Gentleman from Octavia Hall.
Thank you, Mr. Speaker. We'll have a rules meeting at 9:45 in the morning.
All right. I don't see anything further. Recognize the gentleman from Octavia Hall for the motion.
Mr. Speaker, I'd move that we adjourn until 10 a.m. in the morning.
You've heard the motion. All in favor say aye. Opposed, nay. The ayes have it. House adjourned until 10 a.m. tomorrow.